After studying this module, we shall be able to know the meaning of fringe benefits, understand the need for fringe benefits, learn about the types of various fringe benefits in practice in India, know the meaning of labor welfare, identify the various types of welfare services offered by the employers, and explain flexible benefits program and their types.
Fringe benefits refers to the extra benefits, financial and non-financial, provided to the employees over and above the usual fixed basic pay and the various incentives. Employees receive these benefits in addition to their normal compensation. Fringe benefits, whether they are introduced, were relatively insignificant part of the employee's compensation. Today, they are more than a fringe benefit and have increased from time to time as a result of the demands and the pressures from the trade unions. The glossary of the current industrial relations and the wage terms has defined the fringe benefits as supplements to the wages received by the workers at a cost of the employer. The term encompasses a number of benefits: paid vacations, pension, health insurance plans, etc., which usually adds up to the something more than the fringe and is sometimes applied to a practice that may constitute a dubious benefit for the workers. Belcher views these benefits as any wage cost not directly connected with the employee's productive effort, performance, service, or sacrifice.
We will now study the main features of fringe benefits. Number 1. Fringe benefits are supplemental to the employee's regular pay. 2. Fringe benefits are available to all the employees based on their membership in the organization, determined usually on the basis of the length of service and position of the employee in the organization. They are not directly related to performance. 3. The basic purpose of fringe benefits is to enhance the general well-being of employees in the organization. 4. And lastly, these benefits may be statutory or voluntary. While some employers provide these benefits over and above the legal requirements, some restrict themselves to the legislation.
Many factors influenced the concept of fringe benefits. We shall now consider these benefits. Employees demand fringe benefits to accommodate the rising prices and the cost of living. Fringe benefits are preferred over pay hikes because of the associated tax benefits. Pay hikes results in additional tax burden. The growth and the strength of trade unions has resulted in more and varied benefits. Employers too have found that the fringe benefits present attractive areas of negotiations when pay hikes are not feasible. Healthy employer-employee relation can be maintained when the employees are content economically, socially, and psychologically. The various fringe benefits offered to the employees: retirement benefits, security measures, health and safety measures, etc., satisfy them not only economically but also socially and psychologically.
Considering the need for fringe benefits, several legislations have been passed to provide security to the employees against social risks like old age benefits, maternity benefits, etc., and several acts have been passed which specify the minimum health, safety, and welfare standards that employers need to adhere to at their workplaces. Some employers provide benefits to their employees over and above the statutory measures. It is a philanthropic approach on the part of the employer and fosters employee loyalty. Our next topic of discussion would be types of fringe benefits. Fringe benefit is a comprehensive concept and includes both monetary and non monetary benefits such as security measures, retirement benefits, canteen, daycare center, transport facility, education facility, and health and safety measures, and so on. In India, the fringe benefits offered by various organizations may be broadly classified into five categories. Number one, payment for time not worked. 2. Employee security. 3. Safety and health. 4. Personal services and family friendly benefits, which are included in labor welfare. Lastly, and fifth, old age and retirement benefits. We shall now study each component in detail. Payment for time not worked. Payment for time not worked is one of the most costly benefits because many employees receive a large amount of time off and there is no productivity at all during that period. Various types of leave with pay include sick leave, public holidays, vacations, maternity leave, and educational leave. Other benefits for time not worked include rest period, paid lunch periods, clothes change time, get ready time, etc. In each of these cases, full pay is granted for a specified number of days or specific amount of time as laid down by the law.
Employee security. Benefits under this head include retrenchment compensation. It provides the benefit to the workmen in case of termination by the employer for any reason whatsoever, otherwise, that as in punishment inflicted by way of disciplinary action. Section 25F of the Industrial Dispute Act 1947 provides a condition precedent to retrenchment of the workman. A workman who has worked for at least 1 year of continuous service under the employer cannot be retrenched unless he has been given 1 month notice indicating the reasons, etc. At the time of retrenchment, the workman must be paid compensation equivalent to 15 days average pay for every completed year of service or any part of excess of 6 months. The Payment of Wages 1936, the Minimum Wage Act 1948, the Payment of Bonus Act 1965 provide income security to the employees.
Layoff compensation. It is the amount paid on account of failure, refusal, or inability of an employer to give employment to a regular workman and who has not been retrenched. In such a case, under Section 25C of the Industrial Disputes Act 1947, it is provided that employee shall be paid compensation at the rate of 50% of the total basic wage and dearness allowance for all days during which he has been laid off, except for weekly holidays. Lay-off compensation can be paid up to 45 days in a period of 12 months. Safety and health. Section 11 to Section 20 of the Factories Act 1948 contains statutory provisions concerning health, cleanliness, disposal of waste and effluents, drinking water, etc. And Section 21 to 41 of the same Act contains statutory provisions concerning safety, fencing of machinery, hoists and lifts, protection of ice, etc. The Workmen Compensation Act 1923 provides social security and protection to the victims of industrial accidents and occupational diseases. Amount of compensation is paid in lump sum.
The Employees State Insurance Act 1948 provides the periodic benefit to the insured person covered under this Act in case of sickness, maternity, employment injury, and the medical benefit in kind of the insured employees and their families. Sickness benefit is the case of sickness certified by a duly appointed medical practitioner. Maternity benefit in case of sickness arising out of pregnancy, miscarriage, confinement, premature birth of the child, etc. Disable benefit in case of disablement, temporary or permanent, as the case of employment injury. Dependence benefit in case of the insured person dies as a result of the employment injury, his dependents are entitled to compensation. Medical benefit in case of medical treatment, funeral expenses on death. Most of the organizations nowadays provide health services over and above the statutory requirements to the employees, either free of cost by setting up the hospitals, clinics, and dispensaries, or by the reimbursement of the medical expenses borne by the employees.
Personal services and family friendly benefits. Personal services and family friendly benefits include canteens, housing, consumer stores, educational facilities, transportation, employee counseling, etc. Let us now study retirement and old age benefits. Retirement and old age benefits ensure a better future to the employees by providing a fixed sum to the employee on his retirement and during his old age. Benefits under this head include Provident Fund, pension, and deposit linked insurance scheme, the Employees Pension Scheme 1995 and the Employees Deposit Linked Insurance Scheme 1976. Provident Fund, pension, and deposit linked insurance scheme. The Employees Provident Fund and Miscellaneous Provisions Act 1952 provide for three schemes in this regard. The Employees Provident Fund Scheme 1952. Under this scheme, every month the employer contributes a certain percentage, which may vary, of the salary of the employees to the Provident Fund account, and certain sum equal to or greater than contribution payable by the employer is deducted by the employer from the employee's salary as his contribution to the Provident Fund. These contributions are deposited or invested, and the interest earned on these investments is also credited to the Provident Fund account of the employee. The balance keeps accumulating years after year, and on retirement or resignation, the accumulated amount is given to the employee if certain conditions are satisfied. The Employees Pension Scheme 1995. Government introduced this scheme in place of Family Pension Scheme 1971. This scheme provides pension and life assurance benefits to employees on retirement or death if certain conditions are satisfied. Under this scheme, the Provident Fund contribution payable by the employer, representing 8.33% of the employee's pay, is diverted to the pension fund within 15 days of each month. No additional contribution is required. Central government contributes 1.16% of the pay of the employees to the pension fund. Amount of monthly pension varies depending upon the employee's pensionable service and pensionable salary. The Employees Deposit Linked Insurance Scheme 1976. This scheme provides life insurance benefit to the employees. In case of death of an employee, an amount equal to the average balance in the account of the deceased employee during 12 preceding months or period of membership, whichever is less, shall be paid to the persons eligible to receive the amount of Provident Fund accumulations subject to the limit specified under the scheme. The Employees Provident Fund and Miscellaneous Provisions Act 1952 contains the provisions on the applicability of the above mentioned schemes. The next component is gratuity. The Payment of Gratuity Act 1972 provides for a lump sum payment to the employees who render a minimum continuous service of 5 years with the present employer, unless the termination of employment is due to death or disablement. It is payable on employees' superannuation, resignation, death, or disablement due to accident or disease. The amount of gratuity payable shall be at the rate of 15 days average wage on the rate of wage last drawn by the employee for every completed year of service or part thereof in excess of 6 months. The maximum amount of gratuity allowed is rupees 10 lakhs. Medical benefit. Medical benefit is also provided by some organizations to their retired employees and their family members, which creates a feeling of permanent attachment with the organization.
We will now move on to our next topic, labor welfare. Labor welfare is a comprehensive concept and includes a multitude of activities undertaken statutorily or otherwise by the employer for improving the well-being of the workers and their families. In addition to the normal wages and the other economic rewards, welfare activities vary from time to time, from country to country, and within a country from one region to another region. According to Professor H. S. Kirkcaldy, the whole field of welfare is one in which much can be done to combat the sense of frustration of the industrial workers, to relieve them from the personal and family worries, to improve their health, to offer them some sphere in which they can excel others and help them to a wider conception of life. Labor Investigation Committee observes anything done for the intellectual, physical, moral and economic betterment of the workers, whether by the employers, by the government or by the other agencies over and above what is laid down by the law or is normally expected on the part of the contractual benefits for which the workers may be bargained. The basic purpose of the labor welfare is to enrich the life of the employees and keep them happy and satisfied.
We will now consider types of labor welfare, and the first one is ILO classification. The Committee of Experts on Welfare Facilities for Industrial Workers, constituted by the ILO in 1963, classified the welfare services into two groups. Number 1, intramural activities. Number 2, extramural activities. Intramural activities are those which are provided within the precinct of the establishment. It includes facilities such as drinking water, toilets, daycare centers, washing and bathing facilities, rest shelters, canteens, subsidized food, medical aid, etc. Extramural activities which are provided outside the establishment. This includes housing, education facilities, holiday homes, fair price shops, vocational training, transportation, maternity benefits, etc. Next is the classification on the basis of statutory and voluntary welfare work. Labor welfare work may also be divided on the basis of number 1, statutory welfare work, number 2, voluntary welfare work. Voluntary welfare services. Many employers offer the following welfare amenities voluntarily. Housing. According to Radha Kamal Mukherjee, in the household of thousands of slums of the industrial centers, manhood is unquestionably brutalized, womanhood dishonored, and childhood poisoned at its every source. Adequate housing facilities would mean the possibility of home life, happiness, and health. Many organizations, therefore, provide housing loans or construct flats for employees at concessional rates. Some organizations also provide rent free accommodation. Consumer stores. The Indian Labour Conference in 1963 recommended the setting up of consumer cooperative stores in all industrial establishments, including plantations and mine employing more than 300 workers. Most of the organizations which are set up far from towns and provide housing facilities near the organizations set up consumer stores in their campuses to ensure easy accessibility and availability of goods at fair prices. Education. The need for workers' education was stressed by Indian Industrial Commission set up in 1918 and the Royal Commission on Labour set up in 1931. Except in plantations, no industry has statutory obligations in respect of education for workers' children. Education facilities for workers' children are generally provided in industrial township in the form of schools, colleges set up by the government or employers. Many employers reimburse tuition fee of workers' children, provide grants in aid to school where majority of workers' children study, and also provide libraries at workplaces. Transportation. The provision of transport facilities was recommended by the Committee on Labour Welfare 1969. As most industries are located outside towns, companies provide conveyance facility to their employees from residence to workplace and back. Recreation. Most leading companies like Tata's, Infosys, Ranbaxy, Bharti Airtel, etc. nowadays provide facilities for recreation, sports and cultural activities, social clubs, gift shops, spacious gyms, beauty centers, reading rooms, food courts, basketball courts, etc. are regular features in large organizations to make workplace more than a workplace. Other facilities. Companies also provide facilities to employees such as counseling, child care, canteen, legal aid, medical aid, holiday homes, etc., to improve the general well being of the workers.
The Plantation Labour Act 1951. The Act prescribes the following welfare measures for plantation of the workers: canteen where 150 or more workers were employed, crèche facilities where 50 or more women workers are employed, recreational facilities for workers and their children, educational facility for workers' children if they are more than 25 children of the workers in the age group of 6 to 12, housing facility for each worker and his family residing in the plantation as per the standards and specifications prescribed by the state government in the rules, medical aid, sickness allowance, and maternity allowances to workers and their families. Providing such a number and the type of umbrellas, blankets, raincoats to the workers for protection from rain or cold as may be prescribed by the state government. Appointment of a welfare officer if 300 or more workers are employed.
The Motor Transport Workers Act 1961. Following welfare measures are prescribed under this act. Number 1. Canteen, where 100 or more workers are employed. 2. Sufficiently lighted, ventilated, and clean restrooms at every place where motor transport workers are required to halt at night. 3. Provision for such number and type of uniforms, raincoats, or other like amenities to drivers, conductors, and line checking staff for protection from rain and cold. Washing allowance for uniforms shall also be paid to them unless the arrangements for washing of uniform have been made by the employer at his own cost. 4. First aid box in every transport vehicle. 5. Medical facilities for workers at halting stations and operating centers. The Beedi and Cigar Workers Conditions of Employment Act 1966. Every industrial premises should maintain the prescribed standards for lighting, ventilation, and cleanliness. Prescribed washing facilities in every industrial premises where blending or sieving or both of tobacco or warming of beedi in hot ovens takes place. Canteen where 250 or more workers are employed. Daycare center facility if employing more than 30 women workers. And first aid facilities at every industrial premises. The Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996 states prohibition of employment of person with hearing disability, defective vision, or a person with a tendency to giddiness in certain building or other construction work which is likely to involve a risk of any accident either to the building worker himself or to any other person. Temporary accommodation facility with separate cooking place, bathing, washing, and lavatory facilities for such period as the building or other construction work is in progress. Canteen, where 250 or more workers are ordinarily employed. First aid facilities at all places where building or other construction work is carried out. And lastly, daycare center facility where more than 50 female workers are ordinarily employed.
Let us now move on and study about the flexible benefit programs. Flexible benefit programs were developed in the late 1980s with the primary purpose of providing greater flexibility to the employees in customizing their benefit package to their specific needs. Under this program, rather than having one size fits all strategy, each employee is given an opportunity to choose which benefit plan he or she wants, the level of coverage under each benefit plan chosen, and also the dependents covered under each plan. Nowadays, the employers too are interested in these programs. These programs help to attract the bright young talent who want more choice in benefit plans. Employers who wish to be seen as a progressive employer and try to address the varied and changing needs of the young families are those who are interested in introducing these programs in their organizations. Research, however, shows us that in India, the provision of traditional benefits under which a similar set of benefits are offered to all employees is dominant.
We will now study the various types of flexible benefit programs. Some of the common flexible benefit programs are cafeteria plans. It offers greatest flexibility to the employees and potentially greatest cost to the employer. Each employee is assigned a number of flex credits. The employees tailor their own plan from a menu of several benefit plans based on their needs and number of credits available. When we go to the cafeterias, we pick and choose items from a menu, hence the name cafeteria plans. Core Plus Options Plans. Under this plan, some benefits are provided to all the employees on a mandatory basis, which forms the core of the basic level of benefits. It generally includes a small amount of life insurance and limited coverage for health care and disability insurance. In addition, the employees are given an option to enhance their core benefits and purchase coverage in areas outside the core plan through flex credits. Add on plans. More options are added on to the traditional benefit plan. Employees can either enhance coverage for benefits under the existing plan or opt for the new benefits added. Modular plans. Modular plans are the simplest flex plans with two or more predefined plans or modules. Employees with different plan, design, and price tags. In case of the four above mentioned plans, employees use flex credits to purchase the benefits or increase the coverage under the benefit plans. As life proceeds, employees have an option to update the coverage. If the cost of the benefits chosen exceed the assigned flex credits, the employee has to pay the difference through monthly premiums. Flex time arrangements, compressed work weeks, job sharing, telecommuting plans. Flex time allows employees to determine their own starting and stopping hours, when to come to the office and when to leave from the office. Telecommuting allows employees to work from home. They are linked to the workplace by computers and modems. Compressed work week allows employees to work on fewer days in a week with longer hours on those days. Job sharing allows two or more people to share a single job. It is obvious that with choice comes responsibility. It is the employee who has to determine what is best for him. Some, therefore, end up making poor choices. Most of the younger employees are more concerned with take home pay rather than with retirement benefits, whereas older employees are more concerned with retirement benefits. Therefore, management may be required to pressurize workers to take decisions that directly affect their take home pay. With choice, costs to the employer also increases. Employers must be willing to commit significant time and cost for the administration of these plans.
As quoted by Robert Good, if an employee selects the wrong benefit package, the motivational purpose for the company is defeated. Moreover, even just a few bad choices can put the company at severe risk. It is crushing demotivator through the company when the news was spread that X was laid up for weeks without pay or that Y is destitute because Z chose the cash over the survivor benefits. Even though the employees made these choices themselves, the company simply cannot allow such situations to come about. If a company undertakes the heavy and costly administration burden of installing a cafeteria compensation program, it will also be forced to step in and rectify inequities. even though the circumstances were created by the employee's own free choice.
For an effective and successful working of this program, employees should read the flexible benefit guides, review previous year's claim history, and discuss with the family members about the future needs. Employers should commit ample time and money to promote and explain these programs to the employees.
We shall now recapitulate what we have studied so far. Fringe benefits include the benefits over and above the normal compensation paid in the form of wage and salary, employee demand, trade union demands, employer preference, and healthy employer-employee relationship are the reasons why fringe benefits are extended by the organizations to the employees. Type of fringe benefits in practice in India are classified into 5 categories: pay for time not worked, employee security, safety and health, personal and family friendly benefits, labor welfare, and the retirement and the old age benefits. The fringe benefits are governed by various legislations: Industrial Dispute Act 1947, Employee Security; Factories Act 1948, Employee State Insurance Act 1948, Workmen Compensation Act 1923 for safety and health, Employees Provident Fund and Miscellaneous Provision Act 1952, Payment of Gratuity Act 1972, Old Age and Retirement Benefits. Labor welfare are meant to improve the general well-being of the workers. Labor welfare activities can be classified either on the basis of International Labour Organization classification, intramural and extramural, or on the basis of statutory or voluntary welfare work. Voluntary welfare services include transportation, education, housing, recreation, etc. Statutory welfare work is organized by various acts: Factories Act 1948, Plantation Labour Act 1951, Motor Transport Worker Act 1961, etc. Flexible benefit program provide more choices to the employees in designing their benefit package. Types of flexible benefit programs include cafeteria, core plus options, add-on, modular and telecommunicating, flex time arrangements, job sharing, and compressed work week.